Management.
Yes, so Mr. Brinsmead Stockham, we've seen the proposed timetable, which is good in the sense it finishes before the available time. I'm bound to say at the moment we don't think we should spend the first hour and a quarter arguing about supplementary bundles unless you're desperately keen between the pair of you to do that. I think what we would prefer to do is simply to plough on, treat the documents that you might want to refer to as being referred to de bene esse. But do please bear in mind that at the moment we are somewhat sceptical about why we should be referring to any of the transaction documents because of the limitation on the grounds of appeal.
I'm grateful for that, my lord. In that case, there's no need for me to address the application. That seems a perfectly sensible basis on which to proceed.
Are you happy to deal with it now?
Entirely content.
Good. Okay, well, on that basis, I mean, you can take it as read that we've certainly read the judgments of the tribunals, the skeleton arguments. If you do want to go to authorities or materials, then you should certainly not assume we've all read to the same extent, if that's helpful.
For that indication, my lord. My lord, I have here with my learned friend, Mr. Hellier, the appellant and His Majesty's Revenue and Customs, I'll refer to as HMRC.
Yep.
My learned friend, Mr. Krasinski, the King's Counsel, appears for the respondent, Burlington Loan Management, which I'll refer to as BLM. And there are, in addition to the point we've just addressed, my lord, a few matters of housekeeping, which if I can just run through just to make sure we're all singing off the same hymn sheets. The first is just to confirm we've all got the same bundles, which obviously we should have, but it's always worth checking in my experience. So you should have 4 bundles. Can I check?
5.
Well,
6.
Well, we've got 3 authorities bundles, 1 core bundle, and 1 supplemental bundle unagreed, and then
there's the hard copy bundles. It depends if you're working from the PDFs or the hard.
well,
copies.
okay, we may work from both, but go on.
Well, in terms of the PDFs, you should have 4 separate PDFs. Would it, on that note, would it be helpful to assume that you'd like to go to the PDFs, or would you like hard copy references as well?
Well, they should be the same.
They should be the same. Just you'll need to know the bundle number with the hard copies.
Electronically, I have, and others will shout if they have anything different, a core bundle, an authorities bundle, an respondent's unagreed supplementary bundle, and an unagreed supplementary bundle, which I suspect is yours.
That's right.
Those are the 4 electronic.
And you should have only received 1 version of each of those, so we should have the right copies. There is one additional matter, which is that on Monday, BLM produced a couple of supplementary authorities. They're not matters on which I propose to rely, but I did undertake to my learned friend that I would hand them up to you at the beginning. So can I hand those up? There.
Is it right, incidentally, that I can see there's a transcript running in front of me? This is being transcribed.
That is right, my lord, and that was just one of the other points I wanted to address with you in a moment.
Thank you.
And there should be 3 copies. It's 2 documents. There should be 3 copies of each there.
And just to explain, they're just additional bits of OECD commentary, in particular on the principal purpose test in Article 29, because the only reason for including them is that my learned friend has included some anterior commentary on that same article.
Right.
To give context.
That's fine. Can you just tell us where we should put them in the hard copy?
Well, I think it would probably be sensible to go to the back of the authorities bundle.
Right, they're not further extracts from something that is already in.
Can I make a suggestion? Could they go, please, in the front of tab 36, because that's where they fit.
So file 3 of 3.
But they're not on the electronic version.
They're not.
So between pages 886 and 887.
Okay, could they be sent electronically,
Yes.
please?
And they.
My lord, just in terms of the bundles, the core volume should be in one hard copy volume, so that shouldn't cause any difficulty. It's 211 pages. The bundle of authorities is the hard copy. The electronic copy is in one PDF, but the hard copy is split between three volumes. Now, I don't know if we'll need to go to the hard copies, but I don't know exactly where the splits are in terms of the tabs. As I understand it, they were sent out from HMRC's print room, and nobody saw the exact.
If it helps you, my first volume runs from 1 to 16. My second volume runs...
No, 1 to 18.
Ah, okay, well, yes, that's interesting. Mine runs to page 211. My second volume kicks off with tab 19, so if you want to go to
So if we're around
17 and 18,
19, I may have to,
you're in trouble.
guess. Well, that rather serves to emphasise, Model, that it probably is going to be easier to deal with the electronic copies, and that's what I've proposed.
Yep.
Of course, if we need to go to the hard copies, then by all means we can, and I can point you to the tab. We may have to wrestle with exactly which bundle we're in.
Yep.
I should add that both unagreed bundles are one volume, so again that shouldn't cause any problems.
Yep.
My lord, second point was that you'd already adverted to the timetable, which Madame and I had agreed. Obviously, it's indicative, but we will do our best to stick to it. And clearly, the fact that we're not having to deal with the applications will mean we should run well ahead of that. In any event, as you'll have seen from the timetable, we will have ample time.
Yep.
Just in terms of ordering, my own friend obviously has a respondent's notice point. I propose to address that in opening and set out HMRC's position. I'll obviously deal with any points that my learned friend develops in reply. Third point is just one for sort of ease of reference, is just to flag up a couple of the defined terms. In my submissions, I propose to adopt the defined terms from my skeleton argument, and hopefully those should all be self-explanatory, but it's quite easy to just slip into using the pronunciation of various terms that have been used below without explaining what you're actually talking about. So I just wanted to make clear that all the way through the litigation, when the parties have been referring to Lehman Brothers International Europe, which is the UK entity in administration in which the claim, which is the subject of this appeal, was held, they've referred to that LBIE as Libby. So when we're talking about Libby, I'm sure my lord is familiar with Libby, but I just wanted to be clear. We've referred to
at least two of us are very familiar with Libby.
Indeed.
So, yeah.
The Libby claim we referred to as the specific claim in the Libby administration we referred to as the SARD claim.
Yep.
And then SARD Investments Company Limited, which was the original creditor, has been referred to throughout as SICL. So SICL. Only other point is just to note that you'll have seen lots of references to withholding tax or UK withholding tax. Those instructing me are keen for me to emphasise that that term is just used as a helpful label. Withholding tax is not a distinct tax in and of itself. It's simply income tax that's charged by way of withholding. So it's UK income tax withheld at source. It's not in and of itself a distinct tax. It's merely a form of, in effect, enforcing income tax.
Yeah, the withholding is a mechanism.
Indeed, my lord, that's right. And I'll briefly show you the provisions. I'm sure my lady is very familiar with them, but I'll take you briefly. Fourth point was just to deal with transcriber breaks. My lord has rightly noted there is a transcriber. I'm conscious that the court deals differently with breaks. In some cases, depending on the constitution of the court. I'm entirely in your hands, my lord, as to how we want to deal with that.
You're right. I've been in courts where there's been a very firm no to a transcriber break, and I've been in courts where there is a yes. Is the transcriber sitting in front of you by any chance? Okay.
I did agree to do it on the basis there were no breaks, but I do always appreciate a break.
Right. Well, certainly. All right. Well, we've got a little bit of time to spare, and this is probably one of those cases where we can take a short break when the transcriber gives me a nod.
Thank you.
Mid-morning. I mean, if we were running short of time, then that might be different.
No, absolutely, my lord. Shall I sort of proceed on the basis of 11:45 and 3:15? Would that be
something like that?
Okay, I'll try and keep that in mind. I'm sure my junior will punch me in the leg running through it.
Okay.
I should just note the timetable that we've agreed doesn't provide for those breaks, so that will need to be agreed. But there's still plenty of time.
Yeah.
And then the fifth point I was going to deal with was in relation to the applications, my lord. Obviously, I'm now not going to address you on those. I think both parties had thought there was a possibility that you might decide to proceed in this way. I would simply like to emphasise in this context that the reason for putting before the court the documents in HMRC's unagreed bundle is not because HMRC maintains it's necessary for the court to make any additional findings of primary fact. And you'll have seen from the skeleton that HMRC also doesn't challenge any primary facts found by the FTT. HMRC's position instead is that the decisions below disclose errors of law on the face of those decisions, and HMRC is asking the court to set aside and remake those decisions below. And I accept that that would involve remaking an evaluative finding of fact as to the main purpose of BLM, in effect of acquiring the SARD claim. Now, my submission in carrying out that process of remaking the decision, the court should have access to, in my submission, the contemporaneous documents and any further additional relevant information, which would allow the court to make any additional findings of primary fact it considers necessary.
Okay, so just to be clear, you would not be taking us to those documents to support any submission that there was an error of law.
That's correct, my lady. Yes.
Only should this court find an error of law and decide to remake, in which case there's a power to make
Indeed, my lady.
additional findings of fact, no obligation.
Indeed.
Obviously.
Section 14(3) of the Tribunal's Courts of Enforcement Act. I should say, my lady, that the way I'm going to come on to this in a second, but the way I'm going to propose to structure my submissions is to set out first HMRC's positive case. Now, in the context of doing that, I will take you to some of the documents, to some of the unagreed documents, but that is expressly on the basis that I need to demonstrate an error of law in respect of the FTT's decision and the Upper Tribunal.
I mean,
well, that's my lady, if I could say, that's precisely the approach that the Supreme Court took in the lifestyle equities case, which I'm going to take you to.
Okay, it just doesn't seem to be quite consistent with what you confirming what I said earlier.
If I can put it this way, HMRC's positive case is the basis on which HMRC are asking you to remake the decision.
but in theory, we therefore, if the documents are only relevant to a decision which, if we chose to exercise the power to remake, having found an error of law, I mean, we'd only need to get to the documents at that stage, wouldn't we?
Yes, indeed, my lord. Logically, that's right.
Which you won't know until we've given a judgment on the error of law.
That's right, my lord. So I accept
So
I have to demonstrate.
why do we need to go to the documents at all at this stage? It would only be once you know whether we think there's an error of law, then we have to decide, do we remake or do we remit?
So there's no question, my lord, though, that you're entitled to look at the documents. So you should only make any findings of fact if you find an error of law. Fully accept that.
Yeah, but what I'm saying, just as a matter of sequencing, you accept that you have to show an error of law.
Yes.
For which it's, and you don't challenge the findings of fact for that purpose.
Primary
Primary
fact, yes.
fact for that purpose. Therefore, in order to decide whether there's an error of law, I'm struggling at the moment to understand why we need to look beyond the findings in the two tribunal judgments.
So you don't, my lord. All I'm saying,
Right.
all I'm saying is that the way I'm going to structure my submissions is to first of all set out HMRC's positive case. That is the basis on which HMRC are asking you to remake the decision.
But what I'm suggesting to you is that even assuming if we assume for purpose of argument you are right,
Yes.
and there was an error of law,
Yes, my lord.
we will only know that when we've given judgment.
Indeed.
And it's only at that stage that the question might then be said to arise as to whether we should remake or not. And it's only at that stage, in light of what we say on error of law, that we would need to look at the documents for that purpose.
That's all absolutely right, my lord. But in my submission, that doesn't go to the question of the order in which we need to address the points in the hearing. You are perfectly entitled as a court to look at those documents. I'm, I think, entitled to set out what HMRC's positive case is, i.e. the basis on which you should remake the decision. Part of the reason for doing in my submission is that the contrast between that positive case and the way in which the FTT and the Upper Tribunal analysed the case serves to highlight the errors of law in the First Tier Tribunal and Upper Tribunal decisions. But that positive case, and it's not many of the documents I need to take you to, but that is the basis on which simply I'm asking the court to remake the decision. And I would say we'll come on and see it. That's precisely the approach that the Supreme Court took in the lifestyle equities case. You'll see in the judgment, they set out their view of what the right answer was, and then look at the question of whether or not there was an error of law in the decisions below. So I am following the approach of the Supreme Court.
Okay.
For what that's worth. So, my Lord, turning then to an overview of the submissions, the court will have seen from the skeleton arguments that this appeal is concerned with the UK tax treatment of UK...
Sorry, I would just qualify that somewhat. Lifestyle equities, of course, is not an appeal from the tribunals on an error of law.
It's not, my lady.
And it's not subject to the procedure I've just referred to.
Well, it is, my lady, subject to the requirement that there's an error of...
yeah, there is a distinction.
There may be a distinction.
Please make your submissions, but please do bear in mind that we are very focused on the requirement, which the UT also had, that there must have been an error of law in the FTT's decision, and you do not have permission to raise an Edwards and Bairstow ground.
My lady, I fully accept that. I would say in the lifestyle equities case, the Supreme Court is very clearly focused on a challenge to an evaluative finding of fact, and they outline the circumstances in which a court can find an error of law, allowing that evaluative finding of fact to be set aside. And we'll see, I mean, it's almost a reflex, certainly for tax lawyers and possibly for other lawyers, to say, well, it's all just about Edwards and Bairstow. At my submission, that's not true any longer. One needs to see it in the slightly more nuanced way that the Supreme Court did in the lifestyle equities case. And I'm obviously going to come on and show you that. But that's in the context of demonstrating the error of law in the FTT decision.
Okay, so you're now saying we shouldn't be looking at Edwards and Bairstow any longer?
I'm not saying I'm not saying the two decisions are inconsistent.
I think that's quite a radical submission.
I'm certainly not submitting that.
Appeal.
But I'm saying that, if I'm somewhat foreshadowing a submission I'm going to make, Edwards and Bairstow itself is concerned with a situation where the tribunal had just, in effect, listed a series of facts and then come to a conclusion. It said, here are the facts, therefore no trade. And the House of Lords said, well, it's an evaluative finding of fact, if I can paraphrase. You can only challenge that finding if there's no evidence in support of it or no reasonable tribunal could have come to that conclusion. What the Supreme Court in lifestyle equities says is it is different in a situation where you actually have some reasoning that the first instance court has set out. In effect, in Edwards and Bairstow, there was no reasoning, just a series of facts and then an evaluative finding. What the Supreme Court says is if there is reasoning that the tribunal has engaged in, an appeal court is permitted and required to consider that reasoning and see whether or not there is an error of principle, a gap in logic, an inconsistency, or taking into account of a failure to take into account of a material consideration or taking into account of an immaterial consideration. So it's not that they're inconsistent, it's simply that lifestyle equities has filled in a gap.
Well, I understand what you're saying, but I would also be grateful if you could draw our attention to any authority that applies that approach in a tax context. There has been recent commentary on the scope of Edwards and Bairstow.
Indeed, my lady.
I think I commented on it myself.
Yes, there is a case I can take you to. It's
Okay.
the Urenco decision where it's been applied in the tax context. It's fair to say that the Supreme Court's analysis is after Urenco, but it adopts the analysis that's set out in Urenco.
I see. Thank you.
So just somewhat retreading my steps, as the court will have seen, this appeal is concerned with the UK tax treatment of UK source interest received by BLM in Ireland in respect of a debt claim in the administration of Libby, following BLM's acquisition of that claim, the SARD claim from Sickle. And more specifically, it's concerned with the effect of Article 12 of the UK-Ireland Double Tax Treaty. Now, if I can, at the outset, summarise HMRC's case in brief terms, I can do that by reference to 4 propositions, and this is HMRC's positive case. My submission, the profitability of the purchase of the SARD claim for BLM was entirely a function of and attributable to BLM's assumed ability to obtain the benefit under Article 12.1 and Sickle's inability to benefit from an equivalent to Article 12.1. Second, BLM knew that to be the case and entered into the assignment on that basis. Third, in those circumstances, it necessarily follows that in entering into the assignment, BLM had a main purpose of taking advantage, or in other words, obtaining the benefit of Article 12.1, and Article 12.5 therefore applies. Fourth, the decisions of the FTC and the Upper Tribunal to the contrary contain errors of law on their face and should be set aside and remade by this court on the basis of HMRC's positive case. My submissions I've broken down into 5 sections. First, the factual background. I don't propose to run through that in detail, but I will highlight certain matters going to the substantive submissions. Secondly, to frame the issue in dispute. Again, I can be pretty brief on that, but I just want to seek to identify the matters of common ground and thereby seek to frame the sole issue that's in dispute in this case. Third, I will address HMRC's positive case, so set out in more detail the submissions I've just summarised in those 4 propositions. As I've submitted to the court a moment ago, my submission, HMRC's positive case, serves to highlight the errors of law in the decision below, and it also sets out the basis on which the HMRC maintains the court should remake those decisions below. Fourth, I will come on to the errors of law in the FTT decision. Now, that's a slightly different order to the way matters are dealt with in my skeleton argument. In skeleton, we address the Upper Tribunal errors before the FTT errors. But I fully accept that in a case of this nature, involving an evaluative finding of fact by the FTT, I must demonstrate that that decision contains an error of law. And grounds 2 and 3 identify those errors of law, and as I've already addressed the court, they are errors of law of the type identified by the Supreme Court in the lifestyle equities case. Fifth and finally, I will come on to look at the errors of law in the Upper Tribunal decision. Now, this is the point that my lady made at the permission hearing. To some extent, well, if I succeed in demonstrating that the FTT decision is based on an error of law, that should be sufficient for this court to allow the appeal against the Upper Tribunal decision, because the Upper Tribunal would have been wrong to uphold the decision of the First Tier Tribunal. However, I also recognise, as I did at the permission decision, that the Upper Tribunal is the reasoning of the Upper Tribunal is significantly different to that of the First Tier Tribunal. And so I propose to show that that reasoning is also wrong in law, and that's our ground 1. In particular, it doesn't provide any coherent alternative basis to uphold the First Tier Tribunal's conclusion, and it's also important for this court and for HMRC more generally to demonstrate that the Upper Tribunal reasoning is flawed in order to ensure it's not applied in future cases. So if I can turn then to the first of those sections, the factual background, and obviously a lot of this may be familiar already. The factual background reflects the First Tier Tribunal's primary findings of fact at paragraphs 1 to 71 and 162 to 165. I don't propose to go there, but those references for your note. And I just reiterate, HMRC is not seeking to challenge any of those primary findings of fact.
Sorry, can you just give me the paragraph numbers?
Of course, my lady. It's paragraphs 1 to 71
Yep,
and 162 to 165.
thank you.
Now, all of those facts are set out as you would expect in our skeleton argument. There is also a detailed chronology at tab 7 of the core bundle, pages 84 to 87. And again, I commend that chronology to the court. I propose just to run through a brief summary and highlight certain matters of
While you're doing that, I mean,
Yes.
do you suggest that the Upper Tribunal in any way summarised or characterised what the FTT had decided?
No, my lord. So by way of brief summary, the key entities that we are concerned with, first of all, BLM. That was an Irish resident investment company and was the principal European investment vehicle for Davidson Kempner Capital Management, DKCM, which was an asset manager based in New York. BLM was the purchaser of the SARD claim, and it purchased the SARD claim having previously purchased 442 other Libby claims. So the SARD claim was the last Libby claim that BLM bought. Importantly, the First Tier Tribunal held that the purposes of BLM in being concerned with the purchase of the SARD claim were determined by reference to the purposes of the team at DKCM who were dealing with the transaction. And that's the FTT's decision at paragraph 162. So when we're talking about the purposes of BLM, we're really talking about the purposes of the distressed asset investment team at DKCM, which included Miss Gibbons, who was the witness for the FTT. So that's BLM. Sickle, or the SARD Investment Company Limited, that's a Cayman resident company in liquidation since September 2009. It was the original creditor in respect of the SARD claim and sold the SARD claim to BLM, which is what I'll generally refer to as the assignment.
I mean, did it actually sell it to BLM, or did it sell
Sold it via a broker
Yep.
called a New York broker called Jeffries.
Just as a matter of, do you actually, what was the actual mechanics? Was it a sale and then an on sale, or was it?
Back-to-back sales
Yep.
by not identical documents. There are some differences between the documents, but materially identical documents on the same day. So you'll see there's two assignment documents.
Does it matter whether the beneficial interest went direct from Sickle to BLM?
No, because the FTT in my submission rightly held that you couldn't place any weight on the fact that Jeffrey sat in the middle.
Right.
Should be viewed for the purposes of Article 12.5 as an assignment in effect from from Sickle to BLM, because there was no possibility that it would be sold to anyone else. Final relevant entity, or final key entity, is Lehman Brothers International Europe, or Libby. That is a UK resident private unlimited company, part of the global Lehman Brothers group, and became insolvent as part of the 2008 financial crisis, which I'm very conscious my lawyers will know a great deal about. In September 2008, administrators were appointed for Libby. So those are the entities. Turning then to BLM's purchase of Libby claims in general, BLM purchased Libby claims in the period 2011 to 2018, so over the course of a 7-year period. As I've already identified, the SARD claim was the final claim purchased by BLM. In total, BLM acquired 443 Libby claims. Doesn't matter directly for our purposes, but just so you have the note, 332 of those claims, BLM became the lender of record. And those are referred to as direct claims in the FTT decision. And the SARD claim was a direct claim. The remaining 111 claims, BLM purchased a beneficial interest in a Libby claim under a participation agreement, and those are referred to by the FTT as participation claims. The Libby administrators realised a £7 billion surplus from the administration, and in April 2014 began to pay Libby claims in full. You can see that fact most clearly from the chronology, the agreed chronology. For your note, it's page 85 of tab 7 in the call bundle. It's actually the 23rd of April 2014, but nothing specific turns on that date. The SARD claim was not paid in full at that time because the amount of the claim had not been finally determined at that stage.
When you say, yes, it's the principal amount.
The principal amount, indeed. Yes, yes. So because in effect of the surplus, the administrators were required to pay interest on the Libby claims, and if I can summarise the effect of the provisions, the rate had to be the higher of either the Judgments Act 1838 rate, which is 8%, or the rate applicable to the debt apart from the administration. I don't know if it would help to show you that provision, my lord, briefly. It's in the authorities bundle at page 818 of the PDF.
Could I ask my learned friend just to use tab as well, because I'm working on the hard copy?
Of course, I apologise. It's tab 31, page 818. You can see this was the provision that applied at the relevant time. So the Insolvency England Wales Rules 2016 1024, and it's Rule 14.23. It's subsection subparagraph 7. In an administration, any surplus remaining after the payment of the debts proved must, before being applied for any other purpose, be applied in paying interest on those debts in respect of the periods during which they have been outstanding since the relevant date. And then if you go to little c, it provides for the rate of interest, whichever is the greater of the rate specified under paragraph 6, which as you can see is the Judgments Act rate, and the rate applicable to the debt apart from the administration. Now, just as far as the SARD claim is concerned, we're looking at an 8% rate. So turning then to the SARD claim itself, the original creditor, of course, was Sickle. The SARD claim arose from various claims and counterclaims between Sickle and Libby, resulting from a prime brokerage agreement between them. The actual claim, or the sort of concrete version of the claim, if I can put it that way, arose from a deed of settlement between the parties. That is in HMRC's unagreed bundle, starting at page 12. It was a settlement agreement on the 31st of August 2016 between Sickle, Libby, and the administrators of Libby, and that confirmed the principal amount of the SARD claim as 142,164,241.51p. Now, that's a finding of fact from the FTT decision, but if you want to see where that is, it's in clause 4.1.1 of the settlement agreement. That's tab 2, page 18 of HMRC's bundle. That principal amount was paid by Libby to Sickle on the 7th of September 2016. So shortly after the settlement agreement was entered into. But Sickle, of course, retained the right to receive all other amounts payable in relation to the SARD claim, including post-administration interest, which, as we're going to come on to see, was the amount of £90,736,521.36. So principal paid in full in September of 2016. We then need to look at BLM's purchase of the SARD claim. Sickle engaged, or the Sickle liquidators engaged Jeffries Leveraged Credit Products LLC, referred to below as Jeffries, as brokers to market the SARD claim. And as the FTT found as a fact, commercial terms for the sale to BLM were agreed on the 8th of February 2018. And the parties formally entered into the trade on the 12th of February 2018. And that date, the 12th of February 2018, is referred to in the contractual documents as the trade date. Now, I would just flag at this...
Sorry, just give me that again. The
8th
the
of
agreement
February,
in principle was the 8th.
So the agreement to
And-
commercial terms.
And
was
the
on the
formal assignment was the 12th.
No, not quite. Not gonna
That's
come on
the
to-
trade date. That's the contract date.
That's the contract date. Then there, I'll come on to this in a moment, but there's then an assignment agreement on the 9th of March, and then there's a notice of assignment.
Okay, I'm just looking at the chronology. It says Sickle, for the 12th, it says Sickle, BLM and Jeffries formally entered into the assignment.
Yeah, so
That's not right.
Assignment agreement, presumably.
it's commercial terms agreed on the 8th. I mean, it is all set out in the FTT decision, so I'm not trespassing on any findings of fact. Commercial terms were agreed on the 8th. Sickle said it wasn't in a position to formally enter into the agreement on that date because it needed to be in Cayman to do that. And so the parties only formally agreed the assignment on the 12th of February. And then you'll see in the documents that's referred to as the trade date.
Right, so formally entered into is a little bit, that's entered into is formally agreed.
Formally agreed, yes.
So that's the trade.
The assignment itself is the 9th of March, the assignment agreement. Yeah. Now, the specifics of all those dates are, as the court will have seen, relevant to the FTC and the Upper Tribunal's analysis of Sickle's position, because there is a factual question as to what Sickle knew and when, in terms of BLM's ability to rely on Article 12.1. Now, the short point here is that those dates, 8th of February, 12th of February, in my submission are no longer relevant because HMRC's case is now only concerned with the main purpose of BLM. And I'm going to come on to this, but there are clear findings of fact by the FTT that BLM knew throughout the process that it was entitled to benefit from Article 12.1. So that issue simply isn't relevant in the context of BLM. And as you might recall from the permission hearing, that was effectively the reason why HMRC decided it would be simpler and more efficient to only pursue the case in respect of BLM. That issue doesn't arise.
Sorry, to avoid that trade date.
Well, to avoid, there is in effect an additional issue in relation to Sickle that doesn't arise for BLM. So, my lord, then just going on to address a point that you had asked about, there is then a back-to-back assignment affected by two agreements in very similar, if not absolutely identical terms, on the 9th of March 2018. Those assignment agreements are in HMRC's unagreed bundle at tabs 15, page 62 to 85, and tab 16 at 86 to 104. But again, finding a fact by the FTT that those agreements were entered into on that date. Also finding a fact by the First Tier Tribunal that Sickle sold the SARD claim to Jeffries for £82.4 million. And Jeffries then sold to BLM for £83.55 million, such that Jeffries made a commission on the transaction of £1.15 million. Now, importantly, that means that BLM...
Well, in fact, they made a profit.
Jeffries.
I mean, commission, I mean,
it's
simply a question, I mean, it may not matter. As you say, it doesn't matter, but either Jeffries bought beneficially and then sold on at a profit, or alternatively, Jeffries, it was a mechanism by which they effectively held on to a commission, but the beneficial interest went direct from Sickle to BLM. Does it matter?
It doesn't matter, my lord. The First Tier Tribunal records me as having made a submission that it left enough juice for Jeffries to make a profit of £1.155 million. I certainly didn't make that submission, but they made, whether one characterises it as a commission or a profit doesn't matter, but they were up that amount by virtue of the transaction. But we are not concerned with Jeffries' purposes here. It's right to say that Article 12.5 would encompass potentially Jeffries because it concerns the purposes of any person concerned with the assignment.
Well, I suppose what I'm technically asking, is then which assignment are you actually, are we actually engaged with? Were you ever right to look at Sickle?
Well, in my submission, we were certainly entitled to look at Sickle, and the First Tier Tribunal found, again, in my submission rightly, that you are concerned, that Article 12.5 concerns the main purposes of any person concerned with the assignment. Sickle comes within that, those terms.
But are there two or one assignment?
think as a matter of law, there are two assignments.
Yeah, the FTT found that they were preordained, so
The FTT said...
I guess you'd say in tax terms you could view it.
If you're viewing the facts
would be to
realistically,
view it as wrong.
you effectively treat it as an assignment from sickle to BLM. But I think as a technical matter, my lord, if one were asking how many legal assignments are there, I think it must be right that there are two.
And the price for that single assignment is the 82.4 million received by sickle, isn't it?
That is correct, my lord, yes. And then the price paid by BLM is the 83.55.
But it's not paid to sickle.
It's paid to
just paying commission to their broker.
Yeah, they're paying Jeffries that amount. But the fundamental point is that, in my submission, BLM, what we are concerned with really is that BLM paid £83.55 million for the SARD claim. That's ultimately what is critical. Because in my submission, importantly, BLM therefore paid 92% of the value of the SARD claim interest, so the post-administration interest amount, in order to acquire the SARD claim. I'm going to come on to the significance of that in a moment.
Sorry, I got that wrong. I think Jeffries is sickle's broker, isn't it? Not BLM's
Correct.
broker. Yes.
Yes. So we've got the assignment agreements on the 9th of March 2018. And we then have notice of those assignments given to Libby, again by transfer notices in similar terms, on the 19th of March 2018. Again, you don't need to go to them, but for your note, those are in tab 18 of HMRC's bundle, page 106 to 112, and tab 19, 113 to 119. And as a result of those notices, BLM became legally the lender of record. And that's the reason why the SARD claim is a direct claim.
Just as a matter of interest, of course the claim, when we say you're using the term SARD claim, not necessarily just to refer to the interest. How was the assignment, were the assignments expressed to be whatever claims you have or that interest claim?
My lady, that is a question that the First Tier Tribunal addressed.
Yeah.
So the First Tier Tribunal at one stage said, well, are we really dealing with, which if I can paraphrase this, perhaps the question my lady's asking, are we really dealing with an assignment of a debt claim if we're only assigning interest? First Tier Tribunal held, yes, we are. I should say it's been common ground throughout.
Sorry, my question was a factual one about what the assignments provide.
So the way in which the assignments operate, and the Tribunal does refer to this, albeit briefly, is it was an entire assignment of the claims that Sickle had, and then Jeffries had, but subject to the retention by Sickle of the amount of the principal that it had received. So that's referred to as the retained amount. So it's assigning all of the rights that it has, other than the receipt that it's already had. And the First Tribunal, in my submission, rightly held that meant this is an assignment of a debt claim.
But you could characterise that as an assignment of interest.
Well, perhaps economically one could characterise it as that. In my submission, legally one couldn't. For one reason in particular, there could, at the stage of the assignment, there was a possibility that there could have been additional amounts of principal that were payable.
Oh,
So,
right.
so there was still a live issue, for example, and I'm conscious that I'm treading on an area that my lords will know perhaps better than me, but there was still an issue in the waterfall litigation at that stage, for example, as to the application of Bauer and Maris.
Yeah.
And that was, there the question was, well, have any payments that have been made, should those be attributable to interest rather than principal in the first instance?
So just to be clear what the assignments provided for, the only carve-out was the principal amount already received.
Already paid, yes.
Understood.
So any further amounts payable in respect of principal would have been payable to the assignee. And in my submission, that technically must mean that what was assigned here was a debt claim and not just the entitlement to post-administration interest. Of course, Article 12.5 only applies to assignments or creation of debt claims. So I accept that, but in my submission there plainly was an assignment of a debt claim in this case. And the First Tribunal held that.
The possibility of a greater amount of principal. I know the principal was always reserved anyway for Sickle, wasn't it?
The payment that had been received was
so there was a possibility that that BLM could receive more by way of principal.
I think
That
perhaps a
isn't-
theoretical possibility.
That wasn't factored in at all to the FTT's factual findings, though, was it?
No, the FTT. Well, this is all in the context of the question of whether there was a debt claim or not. The FTT's analysis was to say the way these transactions had effect was simply that Sickle retained the principal that had already been paid, and it assigned all other rights. And on that basis, they held that means it's an assignment of a debt claim, not just an assignment of a right to interest.
But this is a further uncertainty,
Well,
which
it is.
actually would increase the value of the debt. That wasn't one of the factors that
No.
the FTT found BLM had taken into account.
No. But in my submission, in terms of the legal analysis, that's just one example to illustrate why it must be the case that what was assigned here was a debt claim.
Understand that.
So we have the assignment agreements. We then have the notices of assignment on the 19th of March, 25th of July.
Just so I've got the reference.
Yes,
and
Mark.
I'm looking at this in your bundle. The assignment is at pages 62 to 63 of your.
Sorry, my lord, you'll have to give me 1 second.
Okay,
to find
it's 62 and 63, I think, of your
So the-
unagreed documents bundle. That's the assignment of claim agreement.
So there are two. One is at tab 15. So starts at page 62. That's from Sickle to Jeffreys, and then the other assignment agreements tab 16, starting at page 86.
Yeah. So just looking to see, to pick up my lords and my ladies'
So if I can,
question
yeah.
as to what was actually assigned.
So if I can, yeah. If you look at page 63, my lord,
Yeah.
you'll see it's really clause 1, A. You can see what's assigned there, but at the end of 1A, you see excluding the retained distribution. And then if you look at the top of that page, there's the definition of the retained distribution, which is the sum of 142 million, i.e. the principal paid by the debtor to the seller on the 7th.
Okay.
So that's why the FTT held that this was an assignment of debt. My learned friend rightly points out, you'll notice just on that page, there is the purchase price is blank, been redacted in the FTT bundles. Now, that redaction actually was removable, so you could actually see the figure anyway. But the tribunal, there's two things. The tribunal, first of all, found as a fact that was the price, the 82.4 million. You can also see it from one of the later emails from the Sickle liquidators. I don't propose to go to that, but I can show you it if that would assist. It's
Just give us the number to write in.
the number to write in is, it is in the skeleton, but it's the 82.4 million.
Is that? Can you give us that exactly?
It's exactly 82.4 million, my lord.
82.4 million.
Yeah, and then that's the first assignment agreement. The second
On what
assignment,
basis it was redacted? Just out of interest.
I don't know, my lord. It wasn't our redaction.
Because we wouldn't have known what Jeffrey's commission or profit was. That would have been a matter of commercial confidentiality originally, or that wouldn't have been something that the parties would have wanted the world to know initially. But by the time it became a public hearing in the FTT, that was no longer confidential.
Okay. Yeah.
My lord, if you want, the FTC finds it as a fact in paragraph 4 of the FTT's decision, so in a sense that should be sufficient. But if you want to see in the documents where you can get that figure from, it's at page 120 of that bundle. Third paragraph of that email. This is an email from the Sickle liquidators. The joint liquidators are pleased to report they've successfully solved Sickle's claim in the Libya administration to a third party for the amount of 82.4 million. Now, we don't need to get that from that document, it's in the FTT decision, but there was a basis for the FTT to make that finding. So that's the assignment. that's dealt with the assignments. We then get to the 25th of July 2018, and that's the date on which BLM received payment of the post-administration interest from the Libby administrators.
So it was received in one amount then?
In one payment, yes, ma'am. Now we know the total figure was the figure of 90.7 million, if I can round down. The payment that BLM actually received was a figure of £72,589,217, and that's because the Libby administrators withheld income tax, and there was withholding tax on the amount. Just to show you the basis for that, it's in the authorities bundle, tab 2, page 9. Section 874 of the Income Tax Act 2007. This section applies if the payment of yearly interest arising in the United Kingdom is made by a company. Here that is the case. To the person by or through whom the payment is made must, on making the payment, deduct from it a sum representing income tax on it at the basic rate in force for the tax year in which it's made. So first point, it has to be yearly interest, and we're going to come on and see the significance of that in a moment. You deduct at the basic rate, and the relevant basic rate at that time was 20%. There are some exemptions from the obligation to withhold tax, particularly in Chapter 11, and the First Tier Tribunal does refer to indirectly to some of those exemptions. I don't propose to take you to them now, but certainly in this case, as we'll see, the position was that as a matter of UK domestic law, withholding tax had to be deducted on that payment.
So when you say Chapter
Chapter
11 of this Act?
Of this Act, yeah. My lord, you can see it at subsection 3, little b.
Yep, I can see it. Yep.
So the Libby administrators deducted the 20% income tax by way of withholding. That was an amount of £18,147,304, and that is the amount of the disputed tax with which we're concerned in this appeal. So it's the amount withheld by the Libby administrators on payment of the SARD claim interest. Now that reference to withholding tax leads on to the point that's addressed in paragraph 20 of our skeleton argument, and that's the three other sets of proceedings that were ongoing, which related to, or didn't relate to, but were relevant to this appeal. Now, the dates and the citations for all of the relevant judgments in those cases are set out in the chronology. Because the parties didn't and don't propose to actually go to any of those decisions, they're not in the bundles in order to save hundreds of pages of judgments, but obviously if it would assist, we can provide them. I don't propose to take you to any of the decisions.
Well, all the references are there.
They're all there, and also
some of them are very familiar to at least one of us, and possibly more.
Indeed, my lord. And the chronology also summarises importantly what actually was found in each of the, in effect, the result. And that's really all either party refers to. So I certainly don't propose to take you to any of the decisions. Yep. But again, as my lord will be extremely familiar, the three streams of litigation, stream probably being a little bit too on the nose, are Waterfall 1, Waterfall 2, and then the withholding tax litigation. So just briefly summarising those and the relevance of those cases. Waterfall 1 was concerned with whether creditors who'd suffered foreign exchange losses on Libby claims could recover that shortfall as a non-provable claim. Now that's referred to in the FTT decision and in the documents as a currency conversion claim. Could such claims be brought against the Libby administrators? On the 17th of May 2017, the Supreme Court had held that no such claims could be brought. So at the time we're concerned with, at the assignment in February 2018, there was no longer a live issue about whether or not currency conversion claims could be brought. However, the possible existence of those claims at earlier times had meant that there was a significant contingency as to the value of some Libby claims. But that contingency had plainly gone by the time we're concerned. That's Waterfall 1. Waterfall 2 dealt with a number of issues, but relevant for our proceedings was both the Barrow Maris point, which we've touched on already, but also the date for the calculation of the post-administration interest. And in particular, was that, in this case, the date of the Libby administration, the date it went into administration, or the date of the termination of the underlying contract? And on that issue, on the 24th of October 2017, the Court of Appeal held that the relevant date was, or the date for the calculation of interest was the date of the administration. Some creditors sought permission to appeal that decision, but ultimately the matter was resolved without an appeal by way of a scheme of arrangement that was approved on the 20th of June 2018, so after the assignment of the SARD claim. So as at the date of the assignment, in this case, the date for the computation of interest was still a live issue, albeit it had been determined by the Court of Appeal. And that is referred to, that issue is referred to by the First Tier Tribunal as the late termination risk.
There had been an application for permission made to the Supreme Court, which had not been resolved by that stage?
That, my lord, I would need to double check that, but that is my understanding of the position, yes. Certainly, it never got to the, well, I should double check that, my lord. I don't want to give you incorrect information, but perhaps my learned junior might just check that. The third strand of the litigation was the UK withholding tax proceedings, and that was concerned with whether post-administration interest is yearly interest within the scope of Section 874 of the Income Tax Act 2007 that we've just looked at. So, were those payments subject in principle to UK withholding tax? Now, on the 11th of October 2016, the High Court had held that it was not yearly interest. On that basis, there was no UK withholding tax due on the payments at all. But on the 19th of December 2017, so approximately 2 months before the assignment of the SARD claim, the Court of Appeal had reversed that decision. The Court of Appeal held that there was an obligation for the Libby administrators to deduct withholding tax from payments of interest on the Libby claims. And that was, therefore, the first time that a UK court had held that the Libby claims were subject to UK withholding tax in principle. At the time of the assignment itself, permission to appeal to the Supreme Court had been refused by the Court of Appeal, as one might perhaps expect. The Supreme Court did later grant permission to appeal. And then on the 13th of March 2019, the Supreme Court upheld the decision of the Court of Appeal. So the Libby administrators were and are required to deduct withholding tax from payments of interest on Libby claims. So that then takes us on to the summary that I set out in paragraph 21 of the skeleton document of the relevant risks to the SARD claim, the relevant risks in relation to the SARD claim at the time of the assignment. And it's paragraph 164, subparagraph 1 of the FTT decision, where the FTT identified the 3 risks that were relevant to the SARD claim. You'll notice page 191 of tab 15 of the core one. So 3 risks at the time of the assignment. First, there was what's called the liquidation lacuna risk, and that was a risk that Libby would go from administration into liquidation, such that there may be no entitlement to statutory interest at all. Second risk was the late termination risk that I already referred to. If the SARD claim interest was calculated from the date of termination of the contract, which you can see from the chronology was the 21st of October 2011, rather than the date that Libby went into administration on the 15th of September 2008, then that would reduce, obviously, that would or shorten the interest period and reduce the amount of interest payable on the SARD claim. Now, that would have required the Supreme Court to reverse the decision of the Court of Appeal on that issue in the Waterfall 2 case. But if that did occur, it would reduce the SARD claim interest, in this case, by approximately £10 million. Third and finally, there was the UK withholding tax risk, and that is the risk that payments of interest on the Libby claims would be subject to UK withholding tax, and that would be an irrecoverable cost for certain creditors, such as Sickle. Now, just to make good that point, there would be no mechanism under UK domestic law for Sickle to recover the withholding tax. The only question would be, is there any mechanism under the UK Cayman Treaty? And the answer is, you have the Cayman Treaty and the authorities at tab 7. But if I can summarise the position, there's no article dealing with interest in the Cayman Treaty, so it would fall under the other income article, which is at page 79 of the authorities bundle. Items of income not dealt with in the foregoing paragraphs of this arrangement arising in a territory, so here arising in the UK, and paid to a resident of the other territory may be taxed in the first mentioned territory. So under the UK Cayman Treaty, the UK is permitted to tax UK withholding tax. I should flag that, this will be familiar to my lady, but that mirrors to a large extent the position in the OECD Model Convention. The OECD Model Convention, the interest article, allows the source state to tax. There's no complete disallowance of source state taxation rights, which, as we'll come on to see, is the position, at least prima facie, in the UK-Ireland Treaty. But the point here is that under the UK Cayman Treaty, the UK was entitled to tax the interest. There's no mechanism for Cayman to say, well, that's not permitted under the treaty. And so the UK withholding tax would stand and there'd be no basis on which to challenge it. Sickle would be able to rely on Article 11, which is the double tax relief article, to avoid double taxation in Cayman. But that, of course, is an academic point because there's no income or corporation tax in Cayman. So, and the Upper Tribunal set this out, but where Sickle would be left is matter of UK domestic law, withholding tax can be charged, no basis in the treaty to recover it. And that's why it's an irrecoverable cost of Sickle.
So the corollary is, as at the date of the assignment, it remained possible that in Sickle's hand the debt was worth 100%.
If the Supreme Court reversed the Court of Appeal's decision, yes, my lord. We'll come on to see, and I'm going to make this submission, but the First Tier Tribunal made clear findings of fact that BLM considered the SARD claim to be worth 80 to Sickle because of the withholding tax cost, and considered it to be worth 100 to BLM because BLM had the benefit of 12.1. So when we look at what the purposes of BLM are, my submission, those are the key findings of fact that we're concerned with. Now, the existence of that withholding tax risk was made clear and acute as a result of the Court of Appeal decision on the 19th of December 2017 that I've already adverted to. And as my lord identifies, for that risk to be removed, it would have been necessary for the Supreme Court to overturn the judgment of the Court of Appeal in the UK withholding tax proceedings. So those are the three risks that the SARD claim was subject to at the time of the assignment. It is important to note in my submission that at earlier stages, the Libby claims, other Libby claims, had been subject to other significant contingencies. So we've seen, for example, prior to the 23rd of April 2014, there was clearly a risk that the principal wouldn't be paid in full. It's only on the 23rd of April 2014 that the administrators confirmed payment in full and the very substantial surplus. We've also seen in the First Tier Tribunal address the possibility, in respect of earlier claims, that there was the possibility of bringing a currency conversion claim, which again would have caused significant...
I'm not sure why those earlier and eliminated risks are relevant.
well, my lord, in my submission, they are not. You'll have seen the First Tier Tribunal. We're skipping forward quite a long way here, but the First Tier Tribunal's reasoning in my submission, one of the errors in the First Tier Tribunal's decision was to say HMRC have rightly treated all the earlier acquisitions as not subject to Article 12.5. Therefore, they must logically accept that this is not subject to Article 12.5. And in my submission, that's plainly an error of law. One of the reasons why that is the case is there were necessarily far more contingency involved in the earlier civil claims. Now, it's an error of law in and of itself.
I'm struggling at the moment, and it may just be me, to make the connection between the existence of contingencies and the legal analysis.
Well, if I could put it this way, in my submission, it's an error of law that the First Tier Tribunal made to have reasoned by reference to those earlier claims at all. However, if it's suggested that there could have been no reason on which to distinguish earlier claims, there are in my submission several bases on which to distinguish those earlier claims. One basis on which you could do that is that earlier claims were subject to other substantial contingencies. But in a sense, all I need to show is that the First Tier Tribunal made the error of law of comparing the position of the earlier claims. That is in and of itself an error in its reasoning.
Were any of the earlier claims pure interest claims, i.e. the principal had already been paid and all that was outstanding was interest?
Some of them were, yes. Yes, my lord. But if I can, I'm conscious of the transcriber rate, perhaps if I can just finish this point, and then that might be a good point to stop. But just to reiterate, by the time of BLM's purchase of the SARD claim, the only three contingencies were those identified by the First Tier Tribunal. Now, the first of those, the liquidation lacuna, the First Tier Tribunal held was not considered to be a real risk at all by BLM. You can see that most clearly in the Upper Tribunal's decision. It gives the example of paragraph 85A in the FTT decision. So if I can show you that first, and then just see what the Upper Tribunal said, which my submission is correct. If you go in the core bundle to page 162, it's tab 15, so the FTT decision.
Sorry, you said the UT decision.
Sorry, I was good. The UT refers to the FTT, so
Okay.
I'll show you. But if it's easier to go to the UT
No,
first.
fine.
The UT refers specifically to.
Sorry, I'm now lost. Where are you? Page 162.
Sorry, my lord. 162 is the FTT decision.
Yes.
It's paragraph 5F.
Paragraph 85A. 80 sub 5 sub A.
Correct, my lord. Yes, page 162.
I'm just making sure it's for the transcribers. Sorry, 80 sub 5 sub A.
Yes. It refers to this is in the summary of Ms. Gibbons' evidence, and it's talking about there the liquidation lacuna risk. You can see at 5A. She did not halfway down that subparagraph. She did not perceive it to be a significant risk at the time when she was analysing the SARD claim because of its low probability. The team had been advised that it was highly unlikely to happen. It was more of a threat used by the Libyan administrators in negotiations than a likely outcome. And the announcement in December 2017 to the effect that the agreement had been reached between the Libyan administrators and the major creditor groups in relation to the terms of what became the scheme arrangement made the liquidation lacuna risk even less likely to materialise. Now, it is addressed elsewhere in the First Tribunal decision as well, but if you go to the Upper Tribunal decision, it's page 94, tab 8. It's rather more succinctly put. Just paragraph 23, subparagraph 1. We'll just ask you to read that. So liquidation lacuna is thought to be insignificant by BLM. Late termination risk, it's obviously a legal risk, but it's clear that that risk existed equally for both BLM and Sickle. And you can see that in the FTT decision at paragraph 164 sub 2. So it's tab 15, page 192. Now, I'm going to come on to this in a moment. These are sub 1 and sub 2 are, in my submission, very important findings of the FTT.
I mean, they may be the same risk, but it doesn't mean the parties assess them in the same way.
Well, my lady, what there is, the only finding we have in the FTT is to the effect here in 162. And again, we say approximately 100% in this context because BLM faced the same liquidation lacuna and late termination.
Sorry, you're
risks.
reading from
164 sub 2, my lady.
164 sub.
Page 192. So it's the middle of that paragraph. Again, we say approximately 100% in this context because BLM faced the same liquidation lacuna and late termination risks as Sickle in relation to the SARD claim. Now, my lady, I think, put to me that we don't know whether it doesn't necessarily mean that they priced that risk the same. Lady, there is no evidence, or more importantly, no finding by the First Tier Tribunal to the effect that the parties priced that risk differently. The only finding we have, or the only relevant findings we have in my submission, are 164 sub 1, where you see back one page that BLM understood the SARD claim to have a value of 80% of the SARD claim risk in Sickle's hands, now, approximately 80%, but plainly that 80% is by reference to the 20% withholding tax. And then the finding in 1642 that BLM viewed the SARD claim as worth 100% of the SARD claim interest in its hands. That is the only finding of fact as to the valuations the parties put on the claim, and that difference in value, the 80% versus the 100%, is entirely attributable to withholding tax. Now, it's right to say the court says approximately 100% and approximately 80%, but that differential of prima facie 20% is attributable only to the withholding tax position.
Well, there's a finding of fact, isn't there, the paragraph beneath ABC on 164, that BLM knew that each of the above risks, which includes C, namely that in Sickle's hands it might be worth 100% if the Supreme Court overturned the Court of Appeal on the withholding tax point.
Sorry, my lord, which paragraph are you referring to?
164.
164
C.
So 164 sub 4C.
No.
Sorry, 164.1. I'm sorry, 164 sub 1. There's the three risks identified, and just below that, there's the reference to BLM knew that each of the above risks would have an impact, which includes the possibility that in Sickle's hands it would be worth 100% because the Supreme Court overturned the Court of Appeal on the withholding tax point.
Indeed, well, there is that possibility, but what the tribunal, does find is that from BLM's understanding of the position was that the SARD claim in Sickle's hand was worth 80% of the SARD claim interest, approximately 80%, but the figure that it alights upon is 80%, and the figure in its hands was 100%. Now, in my submission, that difference of 20%, allowing for the fact that the word approximately is used, but that difference of 20% is entirely attributable to the withholding tax position. And that leaves the third risk, which I've already addressed on, which is the withholding tax risk, and that is, of course, purely a tax risk. Might I just finish this section, and then if we took the transcriber break then, apologise to the transcriber for running slightly long. But really, that's essentially to reiterate the points that I've to some extent already made, which is that the findings of fact as to the position of BLM, which are set out in our skeleton argument at paragraph 22, are those important findings that are made particularly in 1641 and 1642 of the FTT's decision. First, at the time of the assignment, BLM knew that the SARD claim had a value to Sickle of approximately 80% of the interest payable. And it goes on to say, and if I can just show you this, my lord, it's in 191, the top of that paragraph, the tribunal does specifically say of approximately 80% because of the likelihood of sickles suffering irrecoverable UK withholding tax.
Sorry, I've lost where you've just...
Page 191, my lord.
Yep.
164 sub 1. Middle of the top. So the top sub paragraph of that long paragraph. So under the beginning with fact.
Yep.
Middle of that sub paragraph says BLM was well aware of the fact that in the absence of the sale, the SARD claim had a value to sickle of approximately 80% of the interest which was payable in respect of the SARD claim, because of the likelihood of sickles suffering irrecoverable UK withholding tax.
Yep.
So I've made the submission, it must be attributable to the withholding tax. The First Tribunal makes that finding explicitly. Second important finding, and again we've already traversed this ground to some extent, that BLM understood that the SARD claim had a value to BLM of 100%, approximately 100% of the interest payable. That's in 1642, so over the page. Again, at the top of 164 sub 2, top of that paragraph.
That's subject to the Supreme Court upholding the Court of Appeal.
Well, what it says is, because of BLM's ability to reclaim any UK withholding tax which might arise in respect of that interest in the event that the Supreme Court were to uphold the Court of Appeal's decision in the withholding tax litigation.
So it's 100% subject to that uncertainty.
Well, not quite, my lord. What it's saying is, it's saying on the assumption that the decision is upheld.
Well, in any event.
In any event, but they're proceeding on. But in any event, my lady, yes, but on the assumption that the Court of Appeal is upheld, it's assuming that it's worth 100%.
Yeah.
And that can only be because of Article 12.1. Now, it must be right that you proceed on the basis of a decision of this court as to whether or not tax is payable. That's the legal landscape at that time. What the FTT says is, on the assumption that BLM was proceeding on the assumption that the Court of Appeal was upheld, on that assumption it was worth 100 to it, and that can only be because of Article 12.1, because that is the only basis on which BLM would have been entitled to recover the withholding tax. And just to make that point good, perhaps even further, BLM, there is a clear finding that BLM was able to recover the withholding tax, and that it knew it was able to recover any withholding tax, specifically due to its entitlement to benefit from Article 12.1. The FTT makes that finding. You can see that most clearly at 174. Paragraph 174, if I could just ask you to turn up page 1, it's 198. So, paragraph 174, which we will have to come back to when we're looking at the decision in more detail, but 174 runs from 198 to 199. So over the page on 199, in the middle of the top paragraph, thus inevitably BLM's ability to receive UK source interest without UK withholding tax, pursuant to Article 12.1, was one of its tax attributes which it took into account when considering the price which it was prepared to pay for the UK source debts it acquired. The importance of that paragraph is that the tribunal is finding that it's specifically attributable to its ability to benefit from Article 12.1.
Yeah. The FTT, of course, goes on to observe that that was no different from the tax benefits it enjoyed in the Republic of Ireland by virtue of its status.
It does say that. I was obviously going to have to come on and address the tribunal's reasoning, but my submission at this point is the tribunal's finding of fact, and the relevant finding of fact, is that BLM viewed the SARD claim as being worth 100%, or approximately 100% of the SARD claim interest, because of its ability to benefit from Article 12.1, and only because of that. And just to put perhaps a bow on that point,
You say only, but it can only be worth 100 to it by the combination of no withholding tax, or recoverable withholding tax, plus the tax regime it happened to enjoy in the Republic of Ireland. Otherwise, withholding tax would just have been a cash flow cost creditable against its own tax liability.
Well,
Well, it's true, isn't it? It
Well,
can only be worth 100% because it doesn't end up paying tax.
the point, my lady, is that if it had been subject to withholding tax, if it was in the same position as sickle, it would have been worth 80. And so it would necessarily have been a loss-making transaction. There'd have been no profit for Ireland to tax. So
But in either case, it's the combination of the domestic tax position and the treaty.
which domestic tax position, my lady?
Well, in Sickle's case, the fact, as you alluded to earlier, although I don't think we've got a finding, that Cayman didn't subject Sickle to income tax. In this case, the implication, although I don't think we again have a clear finding about it, but the implication is that under its tax status in the Republic of Ireland, BLM didn't pay tax.
Well, just to address that, there's certainly no finding as to the Irish
No.
tax position.
This is the closest you
But
get.
the point is, my lady, that in a sense the Irish tax position, in my submission, doesn't matter because
Well, I'm not sure about that, which is why I'm raising the
Well,
point.
with my submission it doesn't, my lady, because if the SARD claim had been subject to UK withholding tax, which is purely a question of UK domestic law and the treaty, then it would only have ever received gross 80. And so it would necessarily, regardless of what the tax position is in Ireland, it would have been a loss-making transaction. The only basis on which BLM could enter into this transaction on an economic basis is if it is not subject to UK withholding tax. And in my submission, there are clear findings in the FTT decision that BLM regarded that as being the case purely by reason of Article 12.1. And so in my submission, the question as to how that 100 or that 80 is taxed in Ireland is simply not relevant, because the prior question of whether UK withholding tax is due is the question that means whether or not BLM is in a position to enter this transaction at 92 at all. Just on that point about Article 12.1, I just wanted to make one final reference to the FTC decision. Paragraph 175. Just that first sentence. However, the fact that BLM was aware that it was entitled to benefit from Article 12.1 in relation to the interest which was payable in respect of the SARD claim, and took that entitlement into account in calculating the price that it was prepared to offer for the SARD claim, did not mean obtaining that benefit, or more relevantly, taking advantage of Article 12.1 was one of BLM's main purposes. Now, I'm going to come on and address that reasoning again, but the importance in this context is, again, it's the First Tier Tribunal specifically identifying that it's BLM's knowledge that it benefits from Article 12.1 that is the basis for it having the view that the SARD claim is worth 100 to it. Final point just on the late termination risk. We've already addressed this, but you've seen the tribunal held that both parties were subject to the same risk, and in my submission there is no finding of fact to the effect that the parties priced that risk differently. In fact, quite to the contrary, the finding is that BLM, whose purposes we are concerned with, viewed it as being worth 100 to the SARD claim as being worth 100 to BLM and 80 to Sickle. And as we've seen, that was entirely attributable to the withholding tax position, and BLM knew that to be the case. If that is a sensible point to break briefly for the transcriber.
Yes. Okay. Not sure that's going to help us very much, but let's take as close to 5 minutes as we can make it.
All right, able. light if able. Well, that was the first of my 5 sections, so the relevant facts. I then wanted to go on and just frame the issue of a dispute as the second part of my submissions. The court will have seen that there has been, throughout the litigation, a significant amount of common ground on the issues. If I can take that perhaps a step at a time. First of all, it's common ground that absent the UK-Ireland Treaty, so as a matter of purely UK domestic tax law, the SARD claim interest would be subject to UK income tax. Now, the specific provisions, just for your note, and they are referred to in our skeleton, I think in the first footnote. It's the Income Tax Trading and Other Income Act 2005, usually known as ITOIA, sections 3682 and 369. Those aren't in the bundle, but we can provide copies if that would assist, but it's never been disputed that prima facie these amounts are subject to UK withholding tax. And as we've seen, that UK income tax would fall to be deducted at source at the rate of 20% under section 874 of the Income Tax Act 2007, which I showed you before the short adjournment. Again, absent the treaty, there would be no ability for BLM to recover that UK withholding tax. So as a matter of UK domestic tax law, there's no mechanism for recovering that. So the only question then before the First Tier Tribunal and this court is the effect of Article 12 of the treaty. And to see we should probably see the text of that treaty in its natural environment. That's in the Authorities Bundle, tab 6, page 46. The relevant provisions are sub 1, 2 and 5. So interest derived and beneficially owned by a resident of a contracting state shall be taxable only in that state. Now, I touched on the point, and it's a point perhaps that may have occurred to the court. Why don't we have OECD materials on the interest article in the Model Tax Convention before the court? The answer is that interest article is fundamentally different to this interest article, in that, first of all, it doesn't involve a complete surrender of source tax jurisdiction, and also there's no equivalent to Article 12.5 in the OECD Model Tax Convention.
You've mentioned that point twice now, but it probably is also the wider context includes that this is a perfectly standard provision in treaties that the UK has chosen to enter into, albeit not with entities like Cayman, but with most, I would suggest, most major trading nations.
Well, I fully accept it's a very common provision. To some extent, it's a provision that is not unique, but is one that the UK has in general adopted. So as I say, it doesn't follow the OECD.
And in many cases, the US is not alone in that.
Indeed, my lady. But it's merely to address the point. Normally, in a double tax treaty case, you would have before you a lot of the commentary on the specific article.
Yeah. And
the reason why you don't have that is because the OECD model article is different. And in particular, and of course most relevantly for our purposes, there's no equivalent to Article 12.5 in the OECD model. It's not in the interest article. What there is, and I'm going to come on to make submissions about this, is commentary in relation to Article 1 that I will submit specifically addresses provisions in the terms of Article 12.5.
Okay. And
that is one, the failure to recognise that is one of a number of errors in the Upper Tribunal decision. But that's just to explain why you don't have reams of material from the OECD specifically on the interest article. So here you have interest derived and beneficially owned by a resident of a contracting state shall be taxable only in that state. So here you have, by way of crude summary, UK source interest, BLM resident in Ireland, so prima facie Article 12.1 is satisfied. Now, next point you have the definition in sub 2 of the term interest. No dispute here, never has been disputed that post-administration interest is interest. There was the point that we've already addressed about whether or not this involves an assignment of a debt claim. And you see the reference in sub 2 to debt claims of every kind. That is relevant to Article 12.5.
Can I just go back
Yes,
and, as a complete novice, ask what the word derived means in Article sub 1? I understand beneficially owned by, interest beneficially owned by. What does derived and beneficially owned, what does derived bring to the party?
Well, I'm not sure it has much.
Look, it wasn't such a stupid question.
No, my lord, and it's not something. Perhaps it's a point I could take.
I don't know. I mean, it may be a completely irrelevant question. It's just I understand something which qualifies as interest and which is beneficially owned by a resident. That I understand. I'm just not sure what derived means in that context.
I think
it means.
Can I suggest
Yes,
it's often used in the context of source. It's not here, but it's used throughout the treaty. It makes more sense in derived from the other state.
Yeah, and in some sense, it must mean derived from the underlying debt.
But it's often used to mean you get it from
it's
the
derived
other
in the
state.
UK or whatever. Yeah, they sometimes use the words arising as well in the UK.
Okay, it's shorthand for where it comes from.
But it's not correct.
Well, but except here, here it's not really. It's not really relevant because you're here looking only at the state of residence rather than the state of source. The short point, my lord, if this.
But if you look, for example, just on a search in the dividend article, there's dividends derived from a company resident in one state by a resident of the other, where it makes a bit more sense.
Yeah. If I can put it this way, though, there's no dispute that prima facie Article 12.1 is satisfied.
No, I absolutely, and I'm sorry for the slight diversion.
Certainly, no need to apologise, my lord. I mean, it is. There may be cases where that is a relevant question, but in my submission,
this isn't one of them.
It's not one of them.
No. Okay.
But you see, they're taxable only in the state of residence. I've touched already on the point, but I don't think I gave you the references, that it's been common ground throughout. When we turn to Article 12.5, it's been common ground throughout the litigation that the facts of this case involved the assignment of a debt claim. And here we're talking about the SARD claim. For your note, the First Tier Tribunal addressed that at paragraphs 166 to 167 of its decision. And the Upper Tribunal addressed it at paragraph 12. I think the court already has my submissions on that. That the tribunal was entirely right to hold that because this was an assignment of all of Sickles' rights, subject only to the retention of the amount it had already received, that was an assignment of the debt claim. I should add as well that there'd be no reason of policy why Article 12.5 shouldn't at least potentially apply in this context. So Articles 12.3 and 12.4 are not relevant for our purposes. So where we get to then is that Article 12.1 would operate to mean that the SARD claim interest would not be subject to UK tax unless and only unless Article 12.5 disapplies Article 12.1. And that's the only basis on which the case is put or is ever put. So just taking that forward, there is some further common ground. If Article 12.1 applies, then BLM is entitled to recover all of the disputed tax. And as I've submitted, the only reason why Article 12.1 would not apply is if it's disapplied by Article 12.5. And that's why you get to the position that both sides maintained before the First Tribunal and the Upper Tribunal, that the sole issue in dispute is, does Article 12.5 operate to disapply Article 12.1? Now, one final, and in my submission, important point on the wording of Article 12.5 is that that wording was materially, my submission, substantially changed in 1998. by a protocol to the treaty, and I do need to show you both the original wording and you've seen the changed wording here. But if we just go through the process of looking at both materials. So the original wording is in tab 32 of the authorities, page 828. So this is the wording in the original 1976 treaty. It's at the top of that page. You can see it's Article 12 over page sub 5. If I could just ask you to read 12.5. I'm going to make 2 points in relation to that original wording. First, you can see that that is a single main purpose test. So, created or assigned mainly for the purpose of taking advantage of this article. It's not the main purpose or one of the main purposes. The second point, again of significance, real significance in my submission, is you see at the end of that original wording, there is an exclusion for transactions for bona fide commercial reasons. Express exclusion. Now, if we go and look at the effect of the protocol, it's the 1998 protocol agreed between the UK and Ireland. It's the Double Taxation Relief Taxes on Income Ireland Order 1998, which is the statutory instrument.
I mean, just pausing there for a second, just looking at that before you go to the protocol.
Of course.
Would it be right to say that, at least on its face, that language suggests that you contrast taking advantage of the article with bona fide commercial reasons?
In my submission, the way you would read that is, under that original wording, if a transaction was entered into for bona fide commercial reasons, then you fall outside of 12.5.
Yeah, but that's not quite the question I asked you. There is a contrast, or at least linguistically, just on the face of it, between something being for the purpose of taking advantage of this article and not for bona fide commercial reasons. Isn't the draftsman using those two in contradistinction?
I would...
As indicated by the word not in between the two.
Well, and not.
And so, not. You know, it's A and not B.
Well, it could perhaps be said there is some distinction drawn. In my submission, the way it would work, the way in which one would have to apply that, is to determine, first of all, whether or not it was the main purpose to take advantage of the article. And then there is an exclusion from the application of Article 12.5 if the transaction is entered into for bona fide commercial reasons. Now, whether or not one construes reflexively both concepts by reference to another, there may be an argument to that effect. But in my submission, what that wording did was to exclude transactions entered into for bona fide commercial reasons from the scope of Article 12.5. If we can see then the protocol itself, and we've seen the wording it implements, but if perhaps we can see it, the source, it's 840 of the authorities bundle. So this is the 1998 statutory instrument. And as you can see at the bottom of page 840, that inserts the current wording of Article 12.5. Now, there are no other changes to the interest article. It's just a change in the wording of Article 12.5. And in my submission, the protocol changes Article 12.5 in 3 specific and significant ways. First of all, and least relevant for our purposes, it applies Article 12.5 expressly in respect of any person concerned with the creation or assignment of the debt. So it is broadening the scope of the relevant persons to which one must have regard when applying Article 12.5.
I mean, sorry, can I just ask an innocent question? Obviously, when you have legislation brought in, you have explanatory notes. Is there anything equivalent for this provision? And are we going to see it if there is?
So, my lord, yes, there are explanatory notes to this statutory instrument. I can show you them, but my submission is that you should not have regard to those explanatory notes, not because they're unhelpful, but because they are a unilateral statement by the UK as to the meaning of that provision. And one of the submissions I'm going to make on my learned friend's respondent's notice is that unilateral statements by one contracting state as to the meaning of a treaty provision are simply inadmissible to construe the treaty. Now, I can show you them. There's nothing unhelpful. I don't want to sort of put a blindfold over your eyes for strategic reasons, as it were. But I don't want to positively take you to them because in my submission they are inadmissible. But I can show you them anyway, my lord. They are at 844. It's a relatively short explanatory note, as one might expect with a statutory instrument. Explanatory note, this note is not part of the order. And then halfway down, amendments are made to the articles dealing with interest and income not expressly mentioned to provide effective provisions against abuse of these articles. Now, I'm going to come on to submit, and it's been common ground throughout this litigation that Article 12.5 is an anti-abuse provision. No dispute about that at all. So in a sense, the explanatory note doesn't tell us anything. I could note in passing, it doesn't say anything about artificial steps or arrangements. But as I say, I don't want to positively rely on that explanatory note because in my submission, the technically correct answer must be that it's inadmissible.
Why is it technically inadmissible to interpret a UK instrument?
Because ultimately, my lord, the task you are charged with is construing the terms of the treaty. What that statutory instrument does is bring into effect the terms of the treaty agreed between the UK and Ireland. And you are tasked with construing that treaty here, particularly the protocol. And in my submission, there's clear authority to the effect that unilateral statements of either contracting state are not admissible to construing the meaning of.
Yeah, maybe in answer to my lord's question, the initial shortcut is to say the Supreme Court supports the fact that you apply the Vienna Convention, even though it is brought into domestic law by a statutory instrument. And your point about unilateral interpretation is based on the Vienna Convention.
Indeed. And we'll come on to see in the Irish Bank case that this court drew in my submission, an entirely correct analogy with the position for English contract law. You have two parties to a contract. If one party later writes, well, I thought that this provision meant X.
Yeah, obviously.
Well, by analogy, this is exactly the same. This is the UK saying this treaty means X. Now, again, there's nothing unhelpful in the explanatory notes, but
but it doesn't. Sorry, it isn't saying. It isn't saying it means X. It's providing at least some indication as to what the intent of the UK was. It's not quite the same point. Obviously,
well,
it's not a statement as to what it means.
But if you had, to take a contractual case, if you had one party writing down, my intention in entering into this contract was to do X, again, that wouldn't be admissible.
Although, in fact, you say it's common ground that this is an
It is indeed.
anti-abuse provision.
Indeed, my lord. Yes.
So, we probably shouldn't get terribly hung up on that. If it's common ground, whatever abuse means, I mean, that is a different question.
Of course. But the only reason I make the point is I don't want to be seen to positively rely on it, because that could be said to undercut my submissions that I'm going to come on to make in the respondent's notice of saying these unilateral statements are inadmissible.
Right.
So that's the reason I make the point.
Okay.
But going back to Article 3, that reflects the protocol agreed between the two contracting states. And in my submission, as we've seen, it inserted the current wording. And in my submission, it significantly broadened the scope of Article 12.5 in three ways. I've already touched on the point about any person concerned with the creation or assignment, so you're broadening the scope of the relevant persons. Secondly, and importantly, it expanded the test to the main purpose or one of the main purposes. In my submission, that is conceptually a much broader test. That's a matter that courts in this country, particularly in the context of targeted anti-avoidance provisions, have had to grapple with. But a test that incorporates one of the main purposes is much broader, because it's possible for someone to have a number of main purposes. You're not seeking to identify the single main purpose. So it broadens it considerably in that way. And then third, and perhaps most importantly, it removed the carve-out for bona fide commercial transactions. Now, the old article, as we saw, expressly had that wording. In my submission, it must follow that the contracting states intended that Article 12.5 can apply to bona fide commercial transactions. That must follow from this change. And just for your note, paragraph 114 of the FTT records Malone Friends' acceptance that simply the fact that it's a bona fide commercial transaction does not necessarily mean that it falls outside Article 12.5.
Is that FTT? Did you
FTT,
say?
yeah.
Sorry, give me the paragraph again.
114. But in a sense, regardless of Malone Friends' position, in my submission as a matter of law, it must follow that the contracting states intended that. And consequently, in my submission, it must also follow that it's no answer in this appeal, in and of itself, for BLM to maintain that the assignment was a bona fide commercial transaction, that it was in an open market and at arm's length. Because transactions of that nature, in my submission, are potentially within the scope of Article 12.5. And in a sense, coming to this case entirely fresh, it's a little bit like a point that my lady made in QuickFit. If you come to QuickFit, you've got loans at arm's length. You might think on a superficial analysis, well, they can't possibly be an unallowable purpose situation. My submission, this case is of a similar kind. The provision we are dealing with can apply to arm's length transactions in the open market. And that must be a consequence of the amendment that was made in 1998. In my submission, more generally, Article 3 of the 1998 Protocol was a positive decision by both contracting states to materially expand the scope of Article 12.5. And it's that expanded version of Article 12.5 that we are concerned with in this appeal.
Does the wording "take advantage of this article" mean something different following the change?
My lord, in my submission, no. Before and after the change, it meant it should be read to mean obtain the benefit of. So take advantage of, and that in my submission, that is what the FTT rightly found to be the case. I'm going to come on to make that submission now, in fact. Those are the issues and the relevant provisions. The third stage of my submissions was to put HMRC's positive case. And as I've already submitted to the court, that is, in effect, setting out the basis on which HMRC submit that this court should remake the decisions below. And of course, as I've already accepted, I fully accept that I need to go on to demonstrate the errors of law in the FTT and Upper Tribunal decisions. But in my submission, the contrast between the reasoning in those decisions and HMRC's positive case serves to highlight further the errors of law that they made. So I'm proposing to set out HMRC's positive case in 4 sections. First, the correct construction of Article 12.5. Second, the application of Article 12.5 to the facts of this case. Third, the wider implications of HMRC's positive case. And that was a point expressly raised by the court in granting permission to appeal. And then fourth, I propose to address 2 cases that are not actually raised in Malone Friends' skeleton argument. But I think it is right that HMRC address them fully. The first is Kleinwood-Benson, which is a case that my lady raised at the permission stage. And the second is Vietjet, which at least one of my lords may recall. It's a recent decision of this court addressing the equivalent to Article 12.5 in the UK-Japan Treaty. So I propose to address both of those at the end once I've set out HMRC's analysis in toto. So turning first to the correct construction of Article 12.5. On that point, there has again throughout been much common ground. Specifically, there has been agreement on 4 points of construction. First, the general point about how one goes about construing double tax treaties. So what's the general approach? And that is set out in the first, it's never been contentious, and it's set out in the First Tier Tribunal decision at paragraph 82 to 84 and at 111, and in the Upper Tribunal decision at 43 to 44. And despite perhaps a lot of relatively lengthy judgments on the point, where we've ultimately got to is perhaps the unsurprising conclusion that one has to construe treaties in accordance with Article 31 and 32 of the Vienna Convention on the Law of Treaties. If we could go to that now, it's tab 5 of the authorities, pages 28 to 29. The interpretation section also includes Article 33, but that's dealing with different language versions, and we're not concerned with that. So if I could just ask the court to read Articles 31 and 32. Starts at 28 and runs over the page. Now, those are the two provisions, really, that summarise and set out the basis on which the court has to proceed. The primary provision, of course, 31.1, treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of the object and purpose. You then have, in 2, provision for what will constitute relevant context, so an agreement which was made between all the parties in connection with the conclusion of the treaty, an instrument made by one or more of the parties in connection with the conclusion of the treaty and accepted by the other parties as an instrument in relation to the treaty or related to the treaty. And then in 3, you have there shall be taken into account, together with the context, a subsequent agreement between the parties regarding the interpretation and subsequent practice which establishes the agreement of the parties regarding its interpretation. Article 32 then goes on to supplementary means of interpretation, and we may have to address that in the context of Milena Friend's respondent's notice. But for now, the court has seen those provisions. The one other point to highlight is that it's also been common ground, rightly throughout, that OECD and UN commentaries can be taken into account in construing treaties, even if the commentary postdates the treaty. And that's set out by the Supreme Court in Fowler. If I could just show you that, it's at page 404, the authorities bundle, tab 19. The substance of Fowler isn't relevant, we only need to see it for this principle. Paragraph 18, the OECD commentaries are updated from time to time so that they may, and do in the present case, postdate a particular double tax treaty. Nonetheless, they are to be given such persuasive force as aid to interpretation as the cogency of their reasoning deserves. So, commentaries postdating the treaty are admissible and relevant to the construction of the treaty. That's the first point, general approach, common ground. Second, it's always been common ground that Article 12.5 is an anti-abuse provision. And you can see that recorded in the FTT decision at paragraphs 92 to 94. I don't in any sense seek to renege from that position. That's always been HMRC's position. third, it is now clear that it's common ground before this court, that it's sufficient for Article 12.5 to apply that either BLM or sickle satisfied the terms of Article 12.5. The FTT determined that question as a matter of law. You can see that finding, and perhaps we should go to it. It's at 168, subparagraph 3. So page 197 of the core bundle. The FTT's analysis of the law is pretty extensive, but it very helpfully summarised its findings in 168. 168 sub 3. Accordingly, the respondents need to show that either BLM or sickle or both had as its main purpose, or one of its main taking advantage of Article 12.1 by means of the assignment of the SARD claim. Now, that conclusion has not been challenged on appeal, and that is the reason why it's not necessary for HMRC to pursue its case in respect of sickle's main purpose. As I've already adverted to, there are some difficult factual questions in that case as to the relevance of sickle's knowledge when sickle knew that BLM could benefit from Article 12.1 at particular dates. But as we've seen from my outline of the facts, that issue simply doesn't arise in respect of BLM's main purpose, because BLM knew throughout, certainly at the time of the assignment, that it could benefit from Article 12.1, and the FTT found that to be a fact. So, sufficient for either BLM or sickle. We're only concerned here with BLM's main purposes.
I'm sorry to interrupt there, friend. He said twice this morning that there are difficult factual questions about sickle's knowledge. My understanding is that he's accepting the factual findings made by the FTT about sickle's knowledge and when it knew what.
Absolutely, I think I've made that pretty clear. But my point is it's simply not necessary for HMRC to pursue sickle's main purpose on appeal, because it's sufficient for the
It may be just me, I sort of understood the comment to mean, given the factual findings which he doesn't challenge, it might be difficult for him to run the argument in relation to
I hope that's what he meant.
Absolutely,
yeah.
Indeed. I think that was perhaps an area we canvassed on the permission hearing, but yes. Of course, it's an argument we could have run and did run in the Upper Tribunal, but we have not pursued it before this court, and I don't seek to do so. The fourth area of common ground is the meaning of main purpose in Article 12.5. Now, it's common ground, and has been common ground throughout, that the meaning of main purpose in the context of the treaty can be derived from its meaning in UK tax law. In my submission, that is the correct approach. The reason for that is Article 3.2 of the treaty. If I could ask the court to turn that up, it's page 35 of the authorities. It's Article 3, sub-Article 2. I've just asked the court to read that sub-article. Now taking it step by step.
I don't find it that straightforward, actually. It says,
Well,
but as you say, it's common ground.
well, I was conscious from some debates that occurred in the GE case that Milady might not necessarily immediately accept that. My submission is that it is the right approach. So main purpose in my submission is a concept that is not defined anywhere in the treaty.
Yes, but you have to, yes. Well, you need to say it's used somewhere in domestic law in relation to one of the taxes.
And in my submission, my lady,
convention, you say that's enough.
It's used all over the place in relation
Not
to
in
all
this
of the taxes.
context.
Or might as a point of policy.
Certainly
too
not
much,
in relation to withholding tax.
well, income tax, then, my lady.
Yes,
Withholding
I
tax
know
is
you
income
made
tax.
that point.
So, in my submission, it's a concept. Main purpose is a concept. It's not defined in the treaty. And in my submission, it is a concept that does have a meaning for the purposes of UK tax law, and relevantly here, income tax law. It is a concept employed in many, many UK tax statutes, and there is a significant body of case law now as to its meaning, and indeed much of that case law has been written by my lady. Now, that, in my submission, is the right analysis. The meaning from UK domestic law is imported by way of Article 3.2. If there were any doubt about that, there is an alternative approach to the Article 3.2 gateway, which in my submission would get to the same result, which is to say that the UK case law articulates the ordinary meaning of the concept of main purposes, or main purpose. Main purpose, or one of the main purposes, technically. And so they are relevant to the construction under Article 31 of the Vienna Convention in any event. But I would add, it's not a point that's ever been in dispute, and of course the FTT and the Upper Tribunal have both proceeded on that basis. Now, the meaning of main purpose, in my submission, the Upper Tribunal gave a very good summary, the meaning of that concept. It's in the core bundle, page 92. It's paragraph 13, subparagraphs 1 to 7. If I could just, I should say 8 and 9, are dealing with separate points. If I could ask the court just to read those subparagraphs 1 through to 7. Now, that summary is not challenged on appeal. It's been accepted by both parties, and I would endorse it. I would just pick out in particular a couple of the points in that helpful list. First of all, it's a question of fact. I fully accept that. But in my submission, it's necessarily an evaluative or secondary finding of fact, not a primary finding of fact. And that's very clear from the recent Court of Appeal case law on the meaning of main purposes. Second, it's concerned with the subjective purposes of the relevant person or entity. It's not limited to the stated subjective intentions of that person or entity. As you can't just ask the person, what was your main purpose? That's not a definitive answer. It may include some subconscious purposes, and then main purpose has a connotation of importance. And finally, and rightly, a person can have several main purposes for a particular action. And in lots of cases, albeit in my submission this is not one, you do have a situation often where there is perhaps a commercial purpose for a transaction and also a tax purpose. And obviously that can throw up difficult questions of weighing the two purposes, identifying which, if either of them, is a main purpose. I'm going to come on to address that point, but in my submission this is not one of those cases. So that's the meaning of main purpose, and again, that's common ground. In my submission, and on my understanding, the only dispute between the parties in respect of the meaning, or construction of Article 12.5, is the meaning of take advantage of.
Sorry, could you just repeat that? I'm sorry,
That's all right, man.
I'd sort of finished writing something, but
I'm sure I garbled what I said.
No, you didn't. I don't think you did. It was just me.
So, no debate as to meaning of main purpose or main purposes. The only debate between the parties in my submission is as to the meaning of take advantage of those words. And in my submission, that debate has been obscured at times. In particular, it is obscured by the Upper Tribunal decision. But in my submission, it is of significant importance to this appeal, because once Article 12.5 is correctly construed, in my submission, it very strongly supports HMRC's case. Now, I've touched on this already in answer to a question from my Lord Justice Snowden, but HMRC have maintained throughout, it's recorded very clearly in the FTT's decision, that the words take advantage of this article have the same meaning as obtain the benefit of this article. In my submission, HMRC's analysis is clearly supported by both, first of all, the ordinary meaning of the phrase and also the OECD commentary. And I'll come on to demonstrate that that construction HMRC's construction, also represents a coherent and sensible purpose on the part of both of the contracting states. So it evidences a clear purpose on their part, and it is entirely in line with that purpose. Now, I also would accept and endorse a point that's been made in a number of the authorities that we have, that the interpretation of Article 12.5 is a single combined operation, taking account of the ordinary meaning, the context, and the purpose. It's not conceptually an exercise where you sort of go through a tick box exercise of, say, ordinary meaning, and you displace ordinary meaning. I fully accept you have to look at it all in the round. However, in terms of explaining HMRC's analysis and HMRC's construction, it does, in my submission, help to take it in stages. I will, at the end, submit that all of those stages, taken together as one, produce an entirely coherent and sensible construction of Article 12.5 that is correct. So you'll have to forgive me for taking it in stages, but I don't think there's any other way of doing it. So looking first at the ordinary meaning of the phrase, take advantage of. In my submission, the right place to start there, as the FTT did, is the dictionary. Now, it's right to say that there's authority to say it's not always helpful to start with the ordinary meaning. In my submission, here it is. So if I can take you to that definition, and this is the definition that was before the First Tier Tribunal, it's page 958 of the authorities. I should say it's a long entry in the OED for the word advantage. When you get to 958, if my tablet will allow me to, you get the specific definition of to take the advantage, and then a little a with of. So that's to take advantage of little a. But just looking at the whole of that bit of the definition, to take an opportunity provided by favourable circumstances to avail oneself of a personal thing, frequently in a negative sense, to seize an opportunity of unfairly profiting by a personal thing, especially sexually, obviously not considered that, and then with of, specifying the personal thing which is used, exploited, or availed of. Now, in my submission, the relevant words there that we're looking at are to take an opportunity provided by favourable circumstances to avail oneself of a personal thing used, exploited, or availed of. Now, of course,
why wouldn't you focus on the negative sense, given that you accept that this is an anti-abuse provision?
My lord, if I can, I can come to that. I fully accept an anti-abuse provision.
As long as you will.
And in that respect, I would repeat the submissions I made to the First Tier Tribunal. The dictionary says the words take advantage of can be used frequently in a negative sense. Obviously, they are not used exclusively in a negative sense. So one can say, I took advantage of being in Florence to visit the Uffizi. That's not in any sense negative. Now, I'm going to come on to submit that the reason that Article 12.5 is an anti-abuse provision is not simply because of the words take advantage of. You have to look at the whole wording of Article 12.5, and it's the entire wording of Article 12.5 which demonstrates that it's an anti-abuse provision. So that's the dictionary definition. In my submission, that's entirely consistent with the meaning of to obtain the benefit of, to avail oneself of, to take an opportunity provided by favourable circumstances. That's the ordinary meaning, do it in stages. Second point, in my submission, again, a point that was drastically underappreciated by the Upper Tribunal, is the only paragraph in the OECD commentary that is directly relevant to Article 12.5. That is in tab 34, page 859. Now, just to set some context, this is in the context of Article 1 of the 2014 commentary. Article 1 deals with what are called improper uses of the treaty. But if I could ask the court to just read paragraph 21.4 in full.
Sorry, this is designed to be inserted in, among other things, the interest article, which actually is Article 11 in the OECD
Yes, my lady.
model.
But this is the commentary to Article 1. And you can see it recognises in the word. So there's a proposal.
Sorry, commentary, you confused me by saying it's the commentary to Article 1.
So it is, my lady. Article 1 deals with various general matters, including abuses of the treaty. So you can see at the top of the page, commentary on Article 1. This is not commentary to Article 11.
So this provision doesn't, the provision in quotes doesn't presumably appear in Article 1 of the model.
No, it doesn't appear in the model.
It's only the only place we see this text is
in the
where
commentary.
we're looking.
Yes, in the commentary, my lady. And as my lady rightly identifies, it's envisioned that it could be used in respect of Article 10, shares or other rights, Article 11, debt claim, Articles 12 and 21, so other income or royalties as well. Now, the first point to make, my lady, as I'm sure you'll appreciate it, is that, well, stepping back again, what Article 1 does in this section is provide various different possible responses to abuses of the treaty. And this is one of those responses that contracting states could look to when they agree a treaty. The wording that is suggested there in Article 21.4 is exactly the wording of Article 12.5, assuming it's amended to the words interest are inserted in relation to Article 11. But the form of that model provision is identical to Article 12.
When did you say the protocol was introduced? It was actually
1998.
much earlier.
1998.
Yeah.
I'm going to come on to make a submission about that, actually, because I won't foreshadow it, but I'll make a submission in a moment. But just to finish this point, that proposed wording is identical. What the commentary says is, the following provision has the effect of denying the benefits of specific articles of the Convention, so for our purposes Article 12.1, that restrict source taxation, which is what Article 12.1 does, where transactions have been entered into for the main purpose of obtaining these benefits.
Well, it's in error in the first place because it says the main purpose.
Well, my lady, it can hardly tell against my case that
my point is a slightly different one, which we're in very shorthand territory here anyway.
Well, the way the commentary refers to it is obtaining the benefits. It doesn't say anything about artificial transactions or steps, and it's, in my submission, that is the only paragraph of the commentary that deals with a provision in the terms of Article 12.5, and in my submission it is entirely consistent with and supportive of HMRC's construction. What it does, in my submission, is directly equate the words take advantage of with obtain the benefit of. Because the wording used in the model article is take advantage. In my submission, there is no other way to read that. Of course, I accept it's not a long discourse on the meaning of the article, but it is, in my submission, a very clear statement. I'm conscious of time. Perhaps I can just make this final submission, and then that might be a good point to take the short adjournment. This is a point my lady adverted to a moment ago. I would make a further submission in relation to the relevance of this commentary. The current wording of Article 12.5, as we saw, was brought in by the 1998 protocol. 2014, this is the 2014 OECD commentary. You can see in that commentary that the provision was added in January 2003, so 5 years after the protocol. Now, it's absolutely clear, on the basis of the Supreme Court's judgment in Fowler, that this is admissible to construing the meaning of Article 12.5. There can be no doubt about that at all. But in my submission, this court can and should go further on the basis that both the UK and Ireland are members of the OECD, both are given the opportunity to express reservations or observations to the commentary, and neither the UK nor Ireland has expressed any observations or reservations to that commentary. Other states did, they did not. Now, unfortunately, we don't have the reservations and observations section in the authorities bundle. I'm very, very happy to provide that. But in my submission, it must follow that the UK and Ireland should be taken to agree that paragraph 21.4 correctly sets out the meaning of Article 12.5.
Well, that can't be right. As I said earlier, it can't be. You wouldn't accept that entirely, at least, because you've made great pains to say that one of the extensions was to say it's one of the main purposes and not just the main purpose.
My lady, the text isn't wrong. It is right that it will deny the benefit when it's a main purpose to obtain the benefit. It will also apply. Yes, but that doesn't mean the text is wrong. What is stated in the text is correct. Of course, in my submission, the relevance of it is that it equates take advantage of with obtain the benefit of.
What do you understand by taking the benefit of?
Well, no, it actually says obtain the
Obtain. Well, what do you understand by obtaining the benefit?
To get the benefit provided for under Article 12.1. So here, that in the relevant context of our treaty and our facts, that the UK is not permitted to tax.
So that you end there, do you? So if for example, on the facts of this case, well, in any case, the income tax that was being withheld was 20%, and in the other country it would also be 20%. So there's no benefit in any economic sense being obtained at all. It's just that depending on which country taxes, that wouldn't be taking the benefit, would it? Or would that also be?
So the relevance there would be that the test requires it to be the main purpose to obtain the benefit of Article 12.1. And in my Lord's example, it is extremely unlikely and very difficult to envisage a circumstance in which it could be said that it was a main purpose of either taxpayer to obtain the benefit of Article 12.1, because they're both subject to the same withholding tax provisions. There'd be no basis for the transaction to occur by reference to the benefit under Article 12.1, if I can put it that way.
Well, because there's no benefit being obtained in any economic sense.
Well, my submission, that wouldn't be correct. You would still be getting the benefit of Article 12.1, but it wouldn't be a main purpose of entering in.
I understand what you're saying.
So, but it's the combination of main purpose and obtaining the benefit that is the relevant piece in the puzzle there in my submission. So just to finish the point I was making, my lady, in my submission, it's relevant in any event and admissible in any event, but in my submission, this can and should be viewed as a subsequent agreement between the parties as to the meaning of Article 12.5.
I don't think I've ever heard the submission that you should regard OECD commentary as a
It's not addressed in the case,
subsequent agreement. That's not what the Supreme Court says.
There's no decision on the
Well, no, there is a decision which is you give it such weight as it. I forget the precise language.
as its reasoning, cogency of its reasoning permits.
Precisely, not something else.
But that's not on the basis that there's no submission in that case that there was a subsequent agreement. So without more, there's no question, without more, this commentary is relevant and admissible. Fowler establishes that absolutely. My submission is that in the circumstances of this case, the contracting states, who obviously know that they have an article specifically in these terms, and haven't said that they disagree in any way with the terms of that commentary, should be taken to have agreed that this represents what the provision means. And on that basis, it would also be admissible under Article 31.3a. The fundamental point is that there's no question that it's admissible. There's no question that it's relevant. And in my submission, it is the only provision in the OECD commentary dealing specifically with our provision, and in my submission, it's directly in line with HMRC's construction. I'm conscious of the time, my lord.
Right, very good. So we will be back at 2 o'clock. Thank you very much.
Rise in favour.